Preliminary investigation. Definition and nature. Under Section 1, Rule 112, is an inquiry or proceeding the purpose of which is to determine whether there is sufficient ground to engender a well-founded belief that a crime has been committed and the respondent is probably guilty thereof, and should be held for trial. It is more of an executive function, usually conducted by a prosecutor under the executive branch of the government, and the Office of the Secretary of Justice. The main objective is to find whether there is a probable cause, a probability that respondent or one charged of having committed an offense probably did so and therefore should stand trial before the regular courts. More of a statutory right, not a constitutional one, but nonetheless, if granted under a statute, may be demanded as part of a right of an individual under the law. It becomes component of due process under a judicial system. It is preliminary to a possible trial if there's a finding of probable cause. Usually summary in nature. No trial involved, no presentation of evidence is understood during trial of a case. The right to preliminary investigation may be waived. Kinds of probable cause. In preliminary investigation conducted by the executive department, usually through the public prosecutors under the section of justice. Judicial determination of probable cause, usually by the judge to ascertain whether warrants of arrest should be issued against an accused. As to the findings of public prosecutors of probable cause, being an executive function, judges usually don't interfere with such findings. In case of grave abuse of discretion, however, may be questioned by way of petition for certiorari under Rule 65 of the Rules of Court. Officers authorized to conduct preliminary investigation. Provincial and city prosecutors and their assistants. National and regional state prosecutors. Other officers as may be authorized by law. Other officers allowed. Authorized legal officers of Comelec for violation of Omnibus Election Code. Office of the Ombudsman for cases cognizable by Sandiganbayan. PCCG, with the assistance of Office of the Soul, Gen, and other authorized agencies. Judges of municipal trial courts and municipal circuit trial courts are no longer allowed to conduct preliminary investigation, which really belongs to the executive department. When required and not required. Preliminary investigation is required before filing of cases in court when penalty imposable is at least 4 years and 2 months and 1 day. So even cases triable by municipal trial courts should undergo preliminary investigation if penalty is 4 years, 2 months, and 1 day. Procedure for cases not requiring a preliminary investigation. Penalty for cases imprisonment of less than 4 years. By filing complaint directly with prosecutor. By filing complaint or information with the municipal trial court. If directly filed with prosecutor, same procedure as other cases. However, no need for subpoena to be issued and no need for counter-affidavits from opposing party. Motion for reinvestigation is disallowed. Complaint or information may be directly filed with the MTC. If within 10 days the judge finds no probable cause, he shall dismiss case. He may personally examine in writing and under oath complainant and his witnesses in form of searching questions and answers. He may require submission of additional evidence within 10 days from notice. If still he finds no probable cause, he may dismiss the case. With finding of probable cause, he shall issue warrant of arrest, or if already arrested, a commitment order. If no need for a warrant, just a summon, but in case of failure to appear, warrant of arrest to follow. Person arrested lawfully without warrant, for offenses with penalty of 4 years and 2 months, will undergo inquest proceedings, before inquest prosecutor, and if after inquest, after finding of probable cause, case will be filed in court. At this point, person lawfully arrested may ask for a preliminary investigation, after signing a waiver of provisions of Art. 125 of the Revised Penal Code. Such waiver shall be in writing, signed by such person the presence of his counsel. If still under detention, accused may apply for bail. Regularity or absence of preliminary investigation may be raised before accused enters plea. If he fails to do that, deemed waived. Absence of preliminary investigation does not affect jurisdiction of court. It is not a ground to move for quashal of information. Court may remand case to prosecutor for preliminary investigation. Inquest proceedings. Inquest only when accused arrested lawfully without warrant. In other words, detained by proper authorities without being charged yet in court. Technically, not a preliminary investigation but still a summary procedure conducted by inquest prosecutor to determine whether person detained should be further detained or not and be charged in court or released. An inquest prosecutor finds arrest improper, he shall recommend release of person under detention, or after the inquest and he finds there's probable cause, the information shall be filed in court. Inquest prosecutor may ask detainee if he wants to undergo preliminary investigation, but he must sign waiver of provisions of Art. 125 of Revised Penal Code. Inquest must pertain to the offense for which the arrest was made, not any other offense. Illustrative case is that of Beltran vs. People, 523 SCRA 316, 331 336. Where inquest of Beltran was declared void where he was investigated for rebellion when the arrest was for inciting to sedition. Procedure in preliminary investigation proper. Filing of complaint with prosecutor's office for preliminary investigation. Complaint affidavit is filed stating name and address of respondent, accompanied affidavits of complainant, and his witnesses as well as supporting documents in such numbers as there are respondents plus 2 copies for official file. The complaint for purposes of preliminary investigation is different from the complaint instituting criminal prosecution. The affidavits accompanying the complaint shall be subscribed before any prosecutor or government official authorized to administer oaths, even before a notary public. The subscribing officer must conduct personal examination of affiant and see to it that the affidavits were voluntarily executed. Upon filing of complaint, investigating prosecutor has 10 days within which to decide to dismiss the complaint if found to be without cause, or issue subpoena to respondent if he finds need to proceed with the investigation, the subpoena to be accompanied by copy of the complaint and supporting affidavits. The respondent need not be given copies of reply affidavits of other respondents, if any. Respondent shall have right to examine evidence submitted by complainant and copy them at his own expense. If voluminous, the complainant may be required to specify which among the documents he intends to use for examination and copying of the respondent at his expense. Object evidence need not be furnished to party but should be made available for examination and copying by respondent at his expense. Respondent receiving the subpoena with complaint is not allowed to file motion to dismiss in lieu of counter affidavit. Within 10 days he is required to file counter affidavit with supporting documents and affidavits of his witnesses. Said affidavits to be subscribed before any public prosecutor or authorized officer to subscribe who will examine the affiants personally and be satisfied that they were voluntary signed and understood the same. Complaint is entitled as matter of due process to receive copy of counter affidavits. And he may file reply affidavit, but not as a matter of right. Investigating prosecutor may resolve the complaint without such reply affidavit. If within 10 days respondent does not submit counter affidavit, investigating prosecutor may resolve the complaint based on evidence of complainant. Same rule if respondent cannot be subpoenaed. Becomes then ex parte proceeding. The investigating prosecutor may set the case for hearing, for clarificatory questions that he may want to ask. There's no right to cross-examine any party at this point. Within 10 days from termination of investigation, investigating prosecutor shall determine whether there's probable cause for filing of information in court. He shall prepare the resolution and also draft of the information. The information to contain certification that he personally examined the complainant and his witnesses, there's reasonable ground to believe crime was committed, and accused probably guilty thereof, that accused was informed of the complaint against him and he was given opportunity to present countervailing evidence. But lack of such certification is not ground to quash information. Within 5 days from his resolution, the investigating prosecutor shall forward the record of the case to the provincial or city prosecutor or chief state prosecutor or to the ombudsman or his deputy in cases cognizable by the Sandiganbayan in exercise of its original jurisdiction, who shall act on the same within 10 days upon receipt and inform the parties of such action. No complaint or information may be filed or dismissed without approval of the provincial or city prosecutor or the ombudsman, as the case may be. Without such approval, the complaint or information is defective. When the recommendation of investigating prosecutor for dismissal is disapproved by the provincial or city prosecutor or ombudsman, the latter may prepare the information or direct another prosecutor to do so without preliminary investigation. Within 15 days, aggrieved party may file motion for reconsideration, and if denied may appeal within 15 days from such a denial. Prosecutor's ruling is reviewable by the Secretary of Justice, who may reverse, modify, or affirm the prosecutor's determination. Such appeal to the Secretary of Justice does not prevent the filing of the information in the meantime, but appellant and prosecutor shall see to it that pending resolution of appeal, the proceedings are held in abeyance. A motion to suspend arraignment is allowed. Upon filing of information, motion for reinvestigation of the resolution is a prohibited pleading. Where finding of the investigating prosecutor or the section of justice is arbitrary or capricious, remedy is to file petition for certiorari under Rule 65 of the Rules of Court. Filed with the CA, in case resolution of the DOJ is on tax and tariff cases, the petition for certiorari shall be filed with the Court of Tax Appeal. There may be an administrative appeal from the decision of the DOJ on preliminary investigations to the Office of the President under specific occasions, such as when the offense is punishable by reclusion perpetua to death. In case of adverse decision, appeals from the order of the Office of the President to CA under Rule 43, then appeal by petition for review to the SC. The ruling of the Ombudsman in criminal cases shall be elevated to the SC by way of Rule 65. Once the case is filed in court, not only the complaint and information must be forwarded, but together with the resolution of the prosecutor, all the other supporting affidavits and evidence. Within 10 days after filing of information or complaint, the judge shall personally evaluate resolution of the prosecutor. No need for lawyers to file motion for judicial determination of probable cause. After evaluation of the resolution of the prosecutor, the judge may find that evidence failed to establish probable cause and dismiss case. If there is finding of probable cause, based on the evaluation of the judge, he shall order issuance of warrant arrest, but if already arrested, a commitment order shall be issued. A motion to quash warrant of arrest may be filed. Judge may require submission of additional evidence if he is in doubt as to existence of probable cause. Upon filing of information, the judge cannot remand for further preliminary investigation. The ballgame now is on him to determine whether there is basis to dismiss if there is no probable cause. His decision on this is final and appealable as one finally disposing of a case. Appeal would be the proper remedy. Before the judge can issue a warrant of arrest after finding of probable cause, a motion to quash information was filed on ground of lack jurisdiction. Must the court first resolve the motion to quash the information before the issuance warrant of arrest? As decided in the case of De Lima v. Guerrero, G. number 229781. October 10, 2017, the answer is no. The ruling on the issuance of warrant of arrest must be made within 10 days. Dismissal by the judge of the criminal case for lack of probable cause is a final order, and thus appeal is proper remedy, not petition for certiorari under Rule 65. When warrant of arrest not necessary. When complaint or information has been filed pursuant to a lawful warrantless arrest, or warrant of arrest already issued by MTC judge and the accused is already detained. When accused is charged with penalty of fine only. When the case is subject to the rules on summary procedure. When information is already filed in court, even if the DOJ files a motion to dismiss based on its own finding of lack of probable cause, the court will have to make its own independent assessment. The case now is in his jurisdiction. The finding of the DOJ is not binding on the judge.